And my name is Christine Gordon. I'm an attorney in the students' rights practice at Timony Knox. I have been practicing many years, but in the education law field for the last 11 with Scott, representing parents in special education type cases. So we're happy to be here. I'm happy to present today on this topic. It is very important, and we just thank you all for participating.
Okay, so with that said, we're going to jump into this. We have about an hour, and we have a good number of slides to cover. In terms of the topic, you've heard the word important a few different times already. Notice of recommended educational placement. So what we call a NORP in common terms, and also prior written notice under the IDA. That's what we're going to be focusing on tonight. So focus in detail on prior written notice. What does that mean? What the IDEA requires regarding prior written notice. It's a term we all hear. Sometimes, you have to think about what does that actually mean in practice. That's what we're going to cover tonight. We will talk about best practices in terms of dealing with prior written notice given to you as a parent by a school district or a charter school. And we'll also talk about areas to be aware of and some strategies and some maybe ways to respond. We can't give legal advice, but we can certainly share our experience, and we're going to try to do that with some practical examples tonight. We are also going to review section by section the NORP document. The document is, we're going to use an annotated document, which Christine's going to talk about in a little bit. And really the goal is to try to make it understandable. But just starting off for the first slide, prior written notice, what is it? And let's talk about simple terms. Prior written notice means that before the school district takes or refuses to take certain actions, they are required to give parents information. The information has to be in writing, and it has to state what the action is and why they are taking the action or why they're refusing to take the action. So think about the definition, prior written notice. Break it down. Before taking or refusing to take action, that's the prior part. And then giving parents information in writing, that's obviously the written notice part. And this comes up in many ways. Prior written notice is primarily done through a NORP, a notice of recommended educational placement. It is also often done through a permission form, like a permission to evaluate or a permission to reevaluate. But I want to give you some examples just to start with this analysis. Think about an IEP being changed. So a school district or charter school decides we're going to change the SDI or change the goals or add to the present ed levels. Prior written notice is required when a student's IEP is changed. So what the district should do is change the IEP, issue the revised IEP, and issue a NORP with that. That NORP is the statement by the school district. This is what we're offering, and this is why we're offering it. The law is that if there is a proposed change that materially affects the composition of a student's educational program, then a school district or a charter school is required to send prior written notice. It's almost that simple. Some ways this comes up. Let's talk about some examples. And by the way, I'm thinking about preparing for this presentation. I thought about this morning. I was at an IEP meeting this morning, and we spent time. We talked about changing a student's IEP. It was not the annual IEP, and there was probably what we would call modest changes, but important changes. And a question that I almost always ask when I attend an IEP meeting toward the end is, district, are you going to issue a revised IEP, and when? And are you going to issue a NORP, a notice of recommended educational placement with that? And that happened this morning. That's a good question to ask toward the end of a meeting. In this particular IEP meeting this morning, they also were proposing a reevaluation that involved an FBA. And another question was, are you going to issue a permission form? And when are you going to issue that? And what will the content look like? So beyond asking, you then get the document, and obviously you have to carefully review the document. Some quick examples here. A district is required to implement a change in educational placement if they agree and it's a parent request. So think about that. If a district is going to change educational placement, they have to offer a NORP. How about if a district denies a parent request? Parent says, you know what, this program's not working. I want my child in a approved private school, or a supplemental learning support placement, and district says no to that, the law requires a district, if they say no to a parent request, to still issue a prior written notice through a NORP saying this is what the parent asked for. We are not agreeing to do that. And here's why we're not agreeing to do that. So acceptance or I'm sorry, agreement or denial. A couple other examples. Parent makes a request for a district district evaluation of a child. District says, well, there's not a reason to conduct an evaluation. They have to still issue a prior written notice, typically done through a NORP. How about if a district says proposal to conduct an FBA as part of the evaluation? A district needs to issue a prior written notice, again, through either permission form or a notice, sometimes both. And just in terms of the agreement or disagreement, prior written notice is required whether there's agreement or disagreement. Jump back to my example about an IEP meeting today. If the parent and the district said, you know what, we all agree, this is fine, go ahead and implement this IEP that you're going to issue, they still have to issue a prior written notice through a NORP. So everybody knows this is what was offered, this is why it was offered, and there is agreement or disagreement. We're going to get to some of these specifics in a little bit, but prior written notice is a very, very important concept in special ed.
Okay, so I wanted to talk a little about the purpose of the prior written notice. Scott touched on it a little bit, but I think it's important that you understand that, you know, the prior written notice is important because it provides documentation of the proposed and refused actions. It also makes sure, like Scott said, the school and the parents are on the same page about a child's education program. So if you're at an IEP meeting and you discuss many issues at the IEP meeting and request for additional services, you think the district's on the same page as you, but it's not reflected in some type of amendment to the IEP or in the NORP, then the change is not going to be implemented. So this NORP is an important document that helps you know that you're on the same page. It also provides parents with the opportunity to voice any concerns they have or suggestions before an action is actually implemented by the district, and that's pretty important. And it provides the parents with enough information to ensure that the parent understands exactly what it is that the district is proposing or refusing to do. And it's because the prior written notice requires the district to provide reasons and rationale for their decision-making, it allows the parent to determine whether or not there's a basis for their agreement and whether to challenge it later through due process or mediation, and we'll get to that. So on this slide here, this is actually from the IDEA, its regulations, and it specifically addresses what a prior written notice must contain. And it's to ensure that the parents are provided with a comprehensive description of what the action is that's being proposed. So there are a lot of things here that are required, but the important ones, a description of the action an explanation of why the school is proposing or refusing to take that action, and then also a description of each evaluation procedure, assessment, record, or report that the school is using to base its decision, and a description of any other options that the IEP team considered and the reasons why those options were rejected. So these are very important points to give parents to allow them to understand what the school is doing and why not they're going to move forward with a particular action. There are also two other points that the IDEA requires, and that is a statement that the parents of the child with disability have protections under procedural safeguards, and the prior written notice needs to include how parents can obtain a copy of them. And you'll see that in the NORP. There's a statement in the NORP that's used in Pennsylvania. And then also the notice needs to include sources for parents to contact to obtain assistance in understanding these provisions. And that is in line with the requirement that we really want parents to understand what exactly it is the district is proposing.
It's in listening to this, what you've heard a concept of consent. So for you to give consent to or approve, let's say in NORA, you need to understand what is written there. It has to be clear, it has to be stated, it has to be in writing. And that's really the key here. It's notice of what's being offered, why it's being offered, so a parent can make an informed decision and decide whether to agree or to disagree. And there's rights that go with both of those things. Pennsylvania and really the IDA, under the IDA, it's very, very form driven, but we all know that, whether it's the IEP content, which starts off with a form, or the NORP or the permission form, both of which are forms, there are people that fill in the content of those forms. And there's a lot of different circumstances. Sometimes they'll do it rushed in a meeting. Sometimes they'll do it after the fact and may not remember everything. Sometimes there might be potentially due process going on that might influence how they draft the form. So you just have to be really careful in reading the content of the information that's added, that's inserted to the form. We're going to focus now on the Notice of Recommended Educational Placement, the NORP, and a few things that I think are important. One is the purpose. The purpose is to summarize. It's to summarize for parents recommendations from the school. These are recommendations. Again, this is a team concept. IEP team, school district's part of that team, parents are part of that team, district makes the recommendation, parents have a right to agree or disagree, but the NORP is the offer. You need to read it, need to understand what the offer is. The NORP includes a list for the LEA to communicate basically to the parents the proposed action being taken. So if you look at page 1, we'll get to this in the NORP, there's a lengthy checklist of different items, which covers probably 95% of the offers that may happen, from an IEP meeting or interactions between a parent and a school district. Doesn't cover everyone, but most. And districts will check boxes there. Sometimes they'll check multiple boxes. The NORP provides an explanation of the reasons why something is being offered. And again, we're going to get to this, but that's an area where I see usually fairly cursory statements. Sometimes they don't really mean too much. And the why is in a lot of ways as important as the what's being offered and why it's being offered. And then finally, the NORP requires a parent to approve or disapprove, make a decision, and then sign off on it, date it. And there are procedural rights that go with that. And there's also an area related to, for example, checking for an informal meeting or checking mediation or checking due process. And again, that's important. We're going to get to that a little bit. But the NORP is, when you talk, in my humble opinion, when you're talking about the 4 most important documents in special education, IEP, NORP, permission form, and reevaluation report, permission form, reevaluation report, and then progress reporting. They all matter a great deal. There are other forms that matter, but NORP is certainly one of the most important forms in special education. The next slide talks about the types of actions, and hopefully you've seen this before because this is a summary of what's on the NORP form, and there's a lot here. I'm not going to cover every one at this moment, but in terms of the actions that can be taken, a few things to just be aware of. If you look at the different kind of bullet entries there, proposes initial provision of special education. So that's one where you need a NORP for that to happen, and you really need approval, meaning you need consent. And without consent, the school cannot go forward and actually implement initial provision of special education. But if you look at the first 4 entries there, first is proposes, then refusal, then proposes, then refusal. You can see the point I mentioned a few minutes ago where NORPs and prior written notice don't just apply to agreement, they apply to disagreement too, and that disagreement can be from the parent, that disagreement can be from the school district or the charter school. Take a look at these examples. These are the ones that come up most frequently. I would just caution that with other is at the bottom here. And if the district is going to check off other, they need to be very specific and say whatever it is. So if there's something that doesn't arguably fit with any of the 9 or 10 items or more items above that, they need to write it in. You need to be careful in how they draft it. And the parent, you as a parent need to carefully read it. And if they're not getting it right, meaning, hey, this was our agreement, and they're not offering something clearly, then you need to correct that. We'll talk about some ways to respond to NORPS in a moment. Benita, I saw a box pop up to you, but it disappeared. Do you have was there a question? Something to cover?
I was just going to ask if you could talk about like the things I see the most are the placement with disciplinary, the exiting special ed, IEE, and ESY, aside from initial provision. They're like the big ones that I see. And there should be either anything be, like if I ask for an IE, it's okay to check the box, but what should I expect?
Okay, so I'm gonna cover some of them in a little bit, but let's take an example. So if I check IE, if I request an IE, what the expectation is that under the law and under the regulations that there should be consideration of that request by the school district. There should be a timely response. The response should be communicated. It can be communicated. They can call you, they can email you, they can address it in a meeting, but they need to make a decision that is a formal decision. And your NORP is the formal response, which is, yes, we agree to fund an IE, or no, we do not agree to fund an IE, and why. And if let's take the yes part. So is yes, check off, we agree to fund an IE, is that enough? There always are issues with IEs. So it might be, yes, we agree to fund an IE. And IE means independent. It means the parents have the ability to select the evaluator. It also means the district is required to pay the reasonable cost of the IE. But I'm a believer that having that greater clarity in the NORP, so there's no dispute later on. So they say, we agree to fund an IE by a evaluator selected by the parent, and maybe if there's a little description in there, that's what you want. So that greater clarity on something they're agreeing to is important. So independent educational evaluation, IEE. We're going to get to some of these other examples in a bit, and I'm sure some of these are going to come up with questions.
Okay, here we have a section of the IDEA regulations that it's where the prior written notice content was. There's also a provision that requires that the prior written notice be written in a language that's understandable to the general public. So that means it can't be something too complex. It can't be too technical. It needs to be in plain language that doesn't require some advanced degree in education or law or psychology to understand. It needs to be understandable to the general public. And the other requirement is that it needs to be in the native language of the parent. So that is the language that's normally used by the parent of the child. So if the parent doesn't use English at home and instead speaks Spanish, then the NORP or the prior written notice has to be translated into Spanish. And this is just to ensure that the parents completely understand the actions and recommendations that are being taken by the district. So Scott and I in talking about what we were going to present today, and he already mentioned somewhat that we wanted to take everyone through the specific form, the notice of recommended educational placement form, just so everyone is aware of the different sections, what to look for, and we've kind of broken them up on the following slides. So this slide right here, and I should note that we use the annotated version of the NORP that's available on Patten's website at pattan.net. You could get the full version yourself. And that's just the typical form that the schools use for the NORP, but they have what's called annotations and blocks found within the form that provide additional explanations and descriptions of what should be provided in those sections. This is the title here that you would see on the NORP. It's the Notice of Recommended Educational Placement / prior written notice. Those are used interchangeably in Pennsylvania often. And then here's the annotation. The annotation Scott already spoke about is the purpose of this notice is to summarize for the parents what the recommendation is. And then this next slide is what you'll find at the top of the NORP. You'll see a space for the district to fill in child's name, date, name and address of parent or guardian. You want to review that information that's been filled in. make sure your child's name is accurate, make sure your name and your address are accurate. But it's really important that you really are aware of the date that is provided on the NORUP. The date should reflect the date that the notice was provided to you. So sometimes you might see that the program that the districts use, they automatically output a NORUP that has the same date as the IEP. And that is not necessarily the date that you received the NORUP. So that's really important. And that's because in Pennsylvania, parents have 10 days from the date they received the notice to respond to the NORUP by approving or disapproving it. So if the date is not reflective of the date that you received the notice, you would want to contact the district and ask them to either change it, or let's say they sent it in the mail and you received it on the 9th day, you would want to ask them or contact someone and ask them to confirm in writing that you have an additional 10 days to consider whatever's being recommended in the NORUP and to respond. This 10-day deadline for response is very important. There are certain consequences that happen if you do not respond within 10 days. And we'll talk about that more moving forward in further slides. But just briefly, if you approve the NORUP within 10 days and you return it to the district, then obviously the district can move forward in providing whatever the recommended action is, whether it be starting a new placement or a change placement or making changes to the IEP and implementing that IEP. They could do that on the 11th day, or if you agree sooner than the 11th day, if you approve it sooner than that. If you do not respond to the NORUP at all and you just don't return it, as long as it's not the initial provision of special education, then the district can go ahead and act as if, or assume that you have approved the recommended action in the NORUP, and they can, after 10 days, they can go ahead and implement. If you disapprove the action within 10 calendar days and request due process or mediation from the Office for Dispute Resolution within those 10 days, then the district cannot move forward in implementing whatever that recommended placement is or change or whatever the proposed action is. And they have to wait until the dispute is resolved through either mediation or due process. So the 10 days is very important. So you need to be aware of your response deadline and make sure the date and the information at the top is accurate. You can see there's a box on the top right. You'll see that on the NORUP. It says for LEA use only. And that's just a reminder to the school when they see the NORUP, when they receive the NORUP from you, that's where they document the date that they receive it. And that documents that the parent has responded to the recommended placement or action.
Okay. I saw a question pop up about native language. I didn't see the full question, but native language is defined in the regs for the IDEA. And the definition is language normally used by that individual, or in the case of a child, a student, the language normally used by the parents of the child. So the goal of what the slide Christine referenced, and it's an IDEA reg, it's got to be understandable. It's got to be something the parents can read, understand, and make an informed decision on. And, you know, we always learn things in preparing for these presentations, but earlier today, Christine and I were talking about one of the, the language in the regs says written in language understandable to the general public. And I'll tell you what, sometimes we do special education work. We see these all the time, but sometimes reading these NORUPs, it's hard to figure out exactly what they're trying to say there. And if you can't figure it out, then it's hard to agree or disagree. So I would say that if you get a NORUP where it's not clear, then clarify it. It's fine to go back and say, a case manager, a special education teacher, a supervisor, this is what you said. What does this mean? And can we clarify the language in the NORUP? Can you reissue the NORUP so it's clear? Because you have to have that understanding. So understandable to the general public. Benita, your question was if a parent can speak English but don't read Spanish, read only Spanish. Yeah, right. It's got to be understandable to them. So it needs to be translated to Spanish. In terms of other things, other kind of practice comments, and we'll hit this at various points tonight, but the NORUP's a document that they're asking you to sign, and you can write things on the NORP. For example, if there's something that you disagree with in the NORP, but you're approving the NORP later, you check approve and you sign, I would suggest you check where you note that you disagree with a section earlier or question and put your initials there and put the date there. And at least that's kind of a recordation. You're saying that I agreed with the program, but there was a disagreement to something in it. Or you can write a note at the end underneath your signature. So there's different ways to do it, but documentation here and kind of clarity of your response is really important. So don't feel encumbered too much by writing something back on the NORP. There's one little trick with that. We're going to talk about it later with DocuSign, which comes out and really limits your ability perhaps to do this. Jumping back to the slide here. So this is part of the NORP form, the annotated NORP. You can see, dear so-and-so, the obligation is to notify you of the school action. And, basically, what I just wanted to mention is the bottom part in the annotation. Remind the LEA that they must issue procedural safeguards notices when there's a refusal to initiate an evaluation, or if there is a change of placement for disciplinary reasons. So beyond the NORP, they have to issue that additional procedural safeguards. The next slide goes back to the checklist on the NORP. So again, some examples, not to take every one. Fourth one down, refusal to change the identification or evaluation or educational placement of the child. So think about that. It's a refusal. So example, parent requests a change of placement. There is dialogue at an IEP meeting on that issue. And maybe it's not the annual IEP. So maybe there's not the full, going through present education levels and updating information and changing other parts of the IEP. You just at the meeting focus on educational placement, which I would argue might not be the best approach. But if that's what happened and the district says, well, you made this request, we think the current placement is appropriate, it's a refusal. So they need to document that and they need to let the parent know you made the request, we disagree, here's why we disagree, and here's our position, and the parent gets to respond to that. Exiting special education, I think it's the sixth entry down. If there is an exit with special education, usually it's because the district discusses it with the parent, oftentimes before an IEP meeting. Sometimes they'll have an IEP meeting and discuss and say, you know what, your child's making progress. They really have minimal, if any, supports. The supports that are available are generally available in general education, or maybe your child requires a 504 plan, not an IEP. But the bottom line is, if they're going to do that, it's not just, hey, we agree. It's this is our formal offer, and this is the ending time frame for special education eligibility. If you get a NORP offering an exit of special education, I would say be very, very careful, because that's it's a huge change in terms of eligibility and rights and elimination of rights. So you need to think carefully about that. There is second to last one, response to a request for an independent educational evaluation at public expense. Hit that one a little bit already based on the question that Benita had posed, but that's one where I can tell you, Christine and I and our team often see, it seems like there's an agreement to that in a meeting, and then there's disagreement as to what that means. We'll fund an IE, but who's picking the evaluator? Does it have to be from a district list of 3 evaluators? Is there a cost limitation? Is there a time limitation? All those things should be worked out. And as much as you can say in the NORP, have that information in the NORP so it's documented. So you can see the different types of actions taken. These all come up, they're all important, and some, I would say, lead to disputes more often than others.
The second section in the NORP is the description of the action proposed or refused by the school district. So on the first page, you'll see that they check off one of the 9 items on the list. And then this is their opportunity to really provide a narrative description of what it is they're proposing or refusing to do. So if an action is being proposed, it's typically in response to a district recommendation, but it can be in response to a parent request that the district agrees with. So they can they can propose something that the district agrees, and then the parent would just agree in the future. Check that they agree with this proposal, and they would move forward with that action. An action that is refused is in response to a parent request. So here in the annotation, they do provide an example of a description of an action that you might see in an ORAP. So let's say you've asked for additional testing be done, and the school refuses by sending an ORAP that checks the box refusal. So in the description box, you would expect to see something like the parent has requested additional testing to be conducted for purposes of the reevaluation, and the school refuses that testing because. You want to see that description there. It just provides the parent with more information than what's provided in the initial checkbox. On the next slide is the next section, section 3 of the NORP, that provides an explanation of why the school has proposed or refused to take an action. So this is when the school is providing the parent with a rationale for their decision making. And this is where the parent should understand how the school reached its decision. So there are 4 examples here in the annotated version of the NORP. The first, if the district is proposing to or refusing to provide special education, they might explain why with something like evaluation data indicate the child does not meet the eligibility requirements as a child with a disability. The second one is exiting special education. We've talked about this could be the district's explanation where they talk about evaluation data, the child's performance, and all the bases for their decision as to why they think it's appropriate to exit the child from special education. The third one, similar, the student will be graduating with a regular diploma. That's a reason that they would be exiting the child from special education and issuing a NORA. The fourth one we talked about are IEEs. So if the parent is requesting an IEE, the district is refusing, then an explanation may be that the district has conducted an evaluation and considers the data they have to be valid and comprehensive. So while you may disagree with the action being taken or the explanation of why, at least you have the school's position in writing, and you can determine whether you want to challenge that whether you can challenge the proposed action now or in the future.
So Christine, can we stay with that slide for just a minute?
Mhm.
And the last example, let's break it down a little bit. So this is again, explanation of why the school district, in this case, refused to take an action. LEA, the district, conducted an evaluation, considers the evaluation to be valid, comprehensive, etc. So they're refusing the parent request for an IE. That's a situation where you may want to come back and document your particular reasons why you disagree with that position by the district. So maybe you made the request as a parent and you had a discussion with a district person, and then the NORP was ultimately issued, and you may or may not have articulated your reasons why you thought the district evaluation wasn't appropriate, wasn't comprehensive, wasn't complete. They issued the NORP, but after that, you may want to come back and just document in writing, I disagree, I disapprove the NORP, I do not agree with the NORP, and here's why. The evaluation done by the district was not comprehensive. The district failed to conduct an observation, or the observation was conducted virtually, or the testing, the district by their own admission notes that the testing done, the achievement testing, is not reliable because of some factors. So there might be reasons why, and you're doing 2 things if you do this. Number 1, you're making a record. So later on, if the flaw that you're talking about affects the students, affects your child's educational program, you told them and they didn't do anything about it and they disagree with your request, it's going to help your position later. And second is, sometimes they change their mind. So if you push back and you disagree and you have reasons articulated, maybe your response will go to somebody else, maybe it'll go to a supervisor. But documenting a response of disagreement and the why is a good thing to do often. All right, the next slide is a description of other options. So you can read the form introduction says other options the IEP considered and why those options were rejected. We put that in bold. So really here, the school district is required to not address what they offered or what they refused to do if a parent asked for something, but they have to just talk about other options. And you think about a placement. So school district is offering a supplemental educational program or placement for the child. And they considered general education with appropriate supports, and they considered something that was maybe a full-time support. So the bottom line is, if they considered it, it's an option the team considered, that should be written here. Sometimes they do, sometimes they don't write that. Sometimes they don't include it accurately. As importantly, if there's a reason for a rejection, you may not know what the reason is because they may not say it at the meeting, but in their mind, they may have an idea of why they're rejecting the option. And I guess my concern is, if something is identified as an option, but it wasn't talked about at the meeting, it really shouldn't be here. It shouldn't be here written there. So that's where, if they put an option that they didn't consider at the meeting and didn't talk to you about, cross it off and write, this was not considered or discussed at the meeting. If they get into a reason for rejection that is different than what they said at the meeting, that's another thing. You can write a comment at the end, or an email, something documenting. But this is an area where I see, I think, and Christine, I think would agree, we see a lot of canned information, repeated information. Often you wonder how, is that really specific to what happened at this meeting? So I would be particularly careful here in terms of kind of setting things up, because one of the most important parts of the IDEA is consideration, and the parties, the district and the parents can disagree, but they're both required to fairly consider different positions and different options. And if the option wasn't talked about, it shouldn't be here. It's kind of as simple as that. So that means we listen carefully at the IEP meeting, we read carefully what they wrote, and if it's not right, then call them on that. The next slide, again, this is right from the NORA with an annotation, says a description of each evaluation procedure, assessment, record, or report that was used by the district as a basis for whatever decision they make, whether it's an agreement or whether it's a refusal. I think this is a tough one for them to properly do, because really they should be considering a wide variety of data and information and assessments and records and reports. And some may be very current or new, and some may be a year old that are still important. So it's hard to get everything on there. But if you look at this slide, and this actually continues on to the next slide, there's a list of the many things the district can list or include in the IEP, in the NORA, about what they considered. And they never include everything here. But I'll give you a couple to think about. Progress monitoring data. It seems to us that in every decision a district makes about special education for a student, they should be considering progress monitoring data. Think about that. If you're going to talk about a change of placement, well, is something more restrictive, more intense needed? Has the child made progress based on the IEP being implemented? You need to know that. Whether or not a reevaluation should be conducted sooner than 3 years, kind of expediting it. Well, you want to look at, has progress been made? Has the district properly identified the needs, and are the needs being addressed properly, so progress is occurring? Whether or not there should be a change in IEP content, you want to determine, is the student making progress in the areas that are targeted by the IEP? So progress monitoring data is critical. That's an area, I think, Benita, you would agree with me, because I've heard you say this at many IEP meetings, that they either don't have progress monitoring data, or it's not consistent with the goals, or it's not updated, or it's almost indecipherable. So having good progress monitoring data is really important, beyond just saying that this was considered and is plugged into the NORA. There are many other things here listed here. Another one I want to mention is functional behavioral assessments. So if you're talking about behaviors, in school, interfering behaviors, whether it results in discipline or not, a functional behavioral assessment is something that most likely should happen, should be done, and should be done properly. And then it's up to the IEP team to consider that and address, does the child need a positive behavior support plan? If so, what does that look like? What support should be in the IEP? What behavioral goals should we have in the IEP, and can we measure them? But that all goes to consideration of that assessment, a functional behavioral assessment. And then the last one I wanted to mention was assistive technology assessment. That can come in a number of different forms, and that's one that I think is oftentimes overlooked or delayed and not given sufficient attention to. And oftentimes it's critical. If you have a student who has a substantial communication limitation, that needs to be done. It needs to be addressed through the team, and then it needs to be implemented with usually some type of consistent communication strategy and method. But having an assistive technology assessment, if one was done, documented here, is real important in terms of identifying the decision-making by the district. There are other ones that are important. They're all important, but there are other ones that are a little bit unique, like a vocational assessment. I would just say that look at the child's needs, and if the needs are addressed by one of these assessments, the question you need to ask is, did you do it? If you did do it, was it considered? And if it was considered, putting it in this NORP in this section, that's where it should go.
Okay, the next section in the NORAP is a description of other factors, if any, that were relevant to the proposed action or refusal. So this is part of what the IDEA requires in the content of the prior written notice. To be honest, we look at a lot of NORAPs from a lot of different districts, and not a lot of districts really use this section of the NORAP all that often or use it effectively. But this really gives the district one last opportunity to provide all the bases for the decision that they're making. So, you know, you have them locked in writing, at least, to where they can't come back later and add in additional factors and reasons for their proposed action or refusal to act. Some factors that we have seen in the past that some districts have used might be language, cultural issues, communication concerns, health concerns, behavior concerns. A district might note here that a student's taking a medication to manage behaviors and when that started, things along those lines. But as long as anywhere else in the NORAP and in the prior sections, the full bases of their decision is provided, then really not a lot of districts use this section. The next section is the educational placement that's being recommended. And this section informs the parents of the amount and the type of special education supports that the district is recommending and proposing as part of the NORAP. So if the NORAP is being issued with the creation of an annual IEP or with an IEP amendment, then you want to definitely pay special attention to this section and what's written here. You want to look at the IEP that's issued with this NORAP and make sure that they're consistent as far as what the educational placement is being recommended. Many times we go back and look at records and we see that an IEP is issued, but the NORAP is not consistent with what the IEP says. If that's true, then you want to go back to the district and find out what the discrepancy is, because they really should reflect one another. On the next slide, you can see in the annotation, they have the amount of special education supports and the different types of special education supports. And that's what you'll see in this education placement recommendation. The amount of special education supports, there's three types: itinerant, supplemental, and full-time. And this will refer to the total amount of time during the school day that the district is proposing that your child receive special education supports from a special education professional. So that's the teacher and any of the related service providers. So if your child has a one-to-one, that's not included. You can't consider your child to have full-time special education supports just because you have a one-to-one throughout the day. The paraprofessional isn't included in that calculation. Itinerant means that your child is receiving supports or services for 20% or less of the school day. Supplemental means somewhere between 20% and 80% of the school day. And full-time means that your child would be getting supports and services from a special education personnel for 80% or more of the school day. So the IEP team, the district would need to choose one of those three and put that in that last section there, recommended educational placement. And then as far as the type of educational supports, Each NORP should include a description of the type of support the child needs. You could see there's a list of 9 options available to the district to choose. They can choose more than one based on your child's needs. You can see learning support, life skills support, speech and language. You can read the list there. We often see combinations, so a child may need both autistic support and speech and language support, and that's fine to have more than one. Another option you may see under the education placement is when the district is recommending a more restrictive placement. So if they're recommending an approved private school, you would see that here in this section. So full-time emotional support in an approved private school. Oftentimes, the actual school is not listed in the NORUP because one has not been selected yet, or a child has not been accepted yet at the approved private school. So typically we don't see a school's name in there, but just you want to make sure that if the recommendation is for an approved private school, that you see that in there.
So that slide leads to a couple questions. The last comment Christine had was about improved private school. So oftentimes the agreement is we're offering an APS, don't have the APS identified, packet's going to be sent out. Question is, should a parent sign that without knowing which school? And it's challenging. I think you need to talk about what schools packets are going to be sent to, talk about the district's willingness to support the different offers. So if there's 5 schools and 3 accept your child, district, would you agree to any of the 3? And is that something where I, as a parent, will have the ability to select something? So knowing the detail there before you agree to, NORUP that says just APS, I think you have to be careful of. And just in terms of other, let's say it's an offer of a supplemental learning support. We like NORUPs and we like IEPs that have greater description. So for example, it may have that general description, but saying that includes my child being in small group instruction in a learning support classroom for 1 hour per day in math and 1 hour per day in reading. It includes speech and language, whatever else it is. So having description of what that means is important somewhere. They may have spoken about that or described it at the IEP meeting, but that's at a meeting. If it's not in the document, then there's the ability for somebody later to vary from what you expected it would be. So having the clarity, that's another example of just get the clarity so you know what you're reading, you know what you're signing and approving or disapproving. The next slide, and Christine touched on this, but this is a really important area. And it's one where probably in terms of consult, we get the most questions about as lawyers. So it's the parental consent section. And what we have here is directly from the NORUP that is used in Pennsylvania, which again, I'd encourage you to take a look at the patent website, which has the annotated NORUP. Section is titled parental consent. So this is your decision. Do I accept and approve? Do I not? Do I reject? And if I reject, what options am I going to use procedurally? So the first part is please check one of the options. You need to make a decision. As Christine mentioned, we're on the clock because they issued the NORUP. You have a 10-day response period. So a NORUP is not a document to put aside and forget for a while. It's one that needs to be addressed and a decision should be made. You as a parent will need to sign the form. You as the parent will need to return the form to the district. And I would encourage you, if it's not some, like a DocuSign, then you need to make sure that you sign, date, make your decision, check what you're going to check, and then get it back to the district. I would not tuck it into a child's book bag. I would make sure they get it. The best way would either be to physically deliver it and have some acknowledgement, or email it, and not just email it to one person from the district, email it to about 3 people, to a case manager and to a general ed teacher and to a supervisor. So somebody's going to get it, somebody's going to look at it. And you could also, if you know how to do kind of a read receipt, but just make sure they get it. That's the key. And then within 10 calendar days. So it's calendar days. They give it to you on a Friday. You have 2 days right away. It's the weekend. So again, you're on the clock to make a decision. As you can see here, in circumstances where the form is not completed and parent consent is not required, the school will proceed within 10 calendar days if there's no response. So basically, if they send a NORUP and there's no response by you as the parent within 10 days, let's assume it's not a change of placement. The district is going to go forward and implement the IEP. Example, district has an IEP meeting. It's not the annual meeting. They add 2 goals. They add some SDI. They change the present ed levels a little bit. They send the IEP out. And they send you a NORA, and you don't respond. The district, if they follow the law, should implement that IEP, and they should, after the 10 days has expired. There are times where that may not be the case, but I want to just shift over to requesting the kind of the options. And option 1 is I request a meeting to discuss recommendation with school personnel, or I approve the action recommendation, or I do not approve the action or recommendation, and then my reason for disapproval is. So these are all important. They're your rights as a parent to make that election. You're going to check off which one you select. The meeting to discuss the recommendation with school personnel, that can be okay, but I would just caution you, you're still on the clock, in my opinion, with the 10 days. So you better have a meeting that's pretty quick, and you may want to just respond to the NORP and let that meeting happen either after you respond or after the 10 days, because there can be another NORP issued. So I would not just rely on having a meeting and when your rights could be affected by not returning the NORP. Approving the action or recommendation or not approving the action. In simple terms, if you think that the IEP is not appropriate for your child, doesn't meet your child's needs, is not addressing some area sufficiently, then you may want to seriously think about just disapproving the NORP. And that is, again, your statement that I disagree. There's something deficient here. There's something lacking. They may want to have another IEP meeting after that. They may call you and say, well, why did you disapprove? What's a particular reason? And maybe there'll be a revision. So it's solvable, but stating your position is always a good thing. If you are approving, that's a view, the district's going to have a viewpoint that we told you what we were offering. You agreed, you think it's fine. And I can tell you that in due process, we do a lot of due process work and litigation. And oftentimes the school district will say, well, hold on, parent, you're saying what was offered was not appropriate, but we gave you this NORP and you checked that you approve and you thought everything was fine. We thought everything was fine. So I would just be true in terms of your position. If you think it's not appropriate, then tell them that you think it's not appropriate. The ways to not let a district move forward and implement an IEP, there's really a couple primary ways. One is through checking that you disapprove and requesting mediation, and the mediation is requested through effectively the Bureau of Mediation, and there's contact information that's going to be available to you. And the second is through requesting a due process hearing. So you can see the boxes there, but checking the boxes alone does not stop things in their tracks. You probably heard the concept of pendency. That's a whole different maybe topic or presentation. It's a good topic, but pendency applies if you disapprove the NORP and you check mediation or you check due process hearing. If you check mediation or due process and you don't take the next step and file a due process complaint or file a request for mediation, then you're in a position where all you did was return the NORP. And there's a strong argument that that's not sufficient to stop the district from moving forward. So this is a real important section. Think about how you're going to respond and what your response is going to be. And then finally, at the bottom, and this is in bold, if you do not approve the action or recommendation, your child will remain in the current program only if you request a due process hearing or mediation through the Office of Dispute Resolution, which is the point that I just mentioned. So very important section. There's a question, what is the timeline after checking mediation to contact ODR? I would suggest that you contact them promptly, if not immediately. So take care of both pieces. One is I'm checking that I want mediation and I'm getting the NORA back to the school district. And number two, I'm getting online, I'm looking at the mediation. There's a mediation request form. You can complete that online and submit that and get it in, because that's going to stop things in their tracks from moving forward. And you might need to do that sometimes, especially if there's going to be a change of placement. Like I said, Christine and I and our colleagues, this is the area, this parental consent section, where the most questions come up. And this is also an area where On the form itself, if you want to handwrite in some explanation of why I disapproved, here's why I did, write a paragraph and identify your reasons why. That's usually a good practice to do. The next slide is the signature page. We referenced that, so sign, date, and identify your phone number. Just remember, if you approve the IEP, I'm sorry, I wrote down a couple notes about comments. So let me give you a couple of comments. You could write down, I approve the IEP so that it can be implemented. So maybe the IEP is better than it was before, but it's still not quite sufficient. But you're saying, I'm going to approve it, but I'm going to let them know it's not sufficient totally. So write down, I approve the IEP so that it can be implemented, but it still does not meet my child's needs, or something like that. Or maybe you disagree. You can write down, the IEP does not meet my child's needs, I disapprove. And I'm not, you don't make a mediation request, you don't make a due process request. So you're disagreeing, you're letting them know you disagree. Maybe you're writing a reason why you disagree, but you're not checking due process or mediation. So they're going to implement the IEP at that point. So I know there's some different approaches here, but the big thing is, the most important thing is, make a decision and just say what your decision is and give some explanation of why you're making that decision.
And that leads us to the next slide. This is part of the annotation, but it says parents do not approve the recommendation. They should list the reason for disapproval. And that's something Scott touched on, but we always recommend to our clients, if there's anything that you disapprove, you should write that in. There's a section on the NORUP. It didn't show on this slide, but it's a box that says my reason for disapproval is, and you can handwrite that in, you can type that in. There's a lot of white space on the NORUP. You can write it right in there. You could say see attached and attach a different document that has all your reasons for disapproval or your concerns, whether you're going to request mediation or due process hearing or not. It's a great way to document your concerns along the way, in case you're in a due process hearing later and the school says that you were in complete agreement with everything that they were recommending and doing. If you receive the NORUP via DocuSign and you're unable to fill in any of the reasons for your disapproval, you might just want to contact the school and ask them to send it to you via PDF so that you can go ahead and write in your reasons for disapproval on that and send it back via email, as Scott had suggested. Your two options that Scott talked about were mediation and due process hearing. If you disapprove of whatever the recommendation or proposed action is in the NORUP. I just wanted to touch briefly on what they are. Mediation is a less formal, it's meant to be quick and a free and voluntary dispute resolution process. So both the school and the parent have to agree to participate in it. So a lot of times we get a parent that fills out the mediation form, the district receives it, and they either agree or they may disagree to participate in mediation. If they disagree, then a mediation closing letter would be issued, and then you have another 10-day timeline to file for a due process hearing or do nothing and let the proposed action go forward. Mediation is you get a mediator assigned to you. If the school agrees to participate, that person does not work for the school. That person is trained in trying to get you and the district together in a room during a mediation session and to try to resolve whatever your dispute is. The mediator does not make any decisions. It's up to you and the district to agree. If you do come to an agreement during mediation, then a written agreement is drawn up at the mediation session and signed, and then it's enforceable. If you elect a due process hearing, then you would need to file a due process complaint notice form with the Office for Dispute Resolution, and then a hearing officer would be assigned. This is a more formal procedure. It's presided over by a special education hearing officer. They are the ones that make the ultimate decision on the dispute based on evidence and testimony that's provided at a hearing. It could be one hearing day, it could be multiple hearing days, but if you do it within the 10 days that you receive the NORUP, if you request the due process hearing, and if you notify the Office for Dispute Resolution that you're requesting a due process hearing, then your child would remain in their current program and placement during the pendency of that hearing until the hearing officer makes a decision and through any appeal process. So those are the two options that are provided for on the NORUP as far as dispute resolution procedures. And then our next slide is this is on the NORUP. This is the section that just says, please return this entire form to. It'll give the name and address of the person at the district or the charter school who you should return the entire form to. Typically now they have an email address with the name and address so that you can email it. And Scott had talked about this already. What are best practices in returning the form? I would just add that I really do believe that you should include the entire form and not just your signature page. The signature page alone does not have the date on it. It doesn't have what the recommended action is. And it would create confusion later on when you're at a due process hearing if you just have a signature page and not what the recommended action is. And then at the bottom of the slide, this is on the NORUP. There's a list of resources that parents can consult for additional information about the law and your rights. If you have any questions about what are in the NORUP, that's usually the 4th page of the NORUP. It has a list of different resources that you can contact and their phone numbers and contact information. So this is like the Disabilities Rights Network, the Office for Dispute Resolution, the ARC of Pennsylvania. There's a parents consult line that you could call up, and that's included in every NORUP that's issued.
And the last slide we have, and we have this slide in many presentations because it's so important, the concepts, but importance of documentation. So you've heard us kind of preach tonight in terms of share your position and usually do it in writing. You can have meetings, you can talk about things, that's fine, that's usually beneficial, but in writing also. Could be email documentation, it could potentially be text, it could be what you write on the NORUP. So in the context of prior written notice that we're speaking of tonight, we're seeing more and more, utilization of things like DocuSign, where you get the document sent to you by the district, and you really only have the option of signing your name and potentially checking I approve or I disapprove, and don't have the ability to, add comments in there. So if you're going to do that, then there needs to be a separate method, separate vehicle to communicate. So send an email, something in writing documenting that supplemental piece of information you want them to know, and try to send that back concurrently with whatever document you're signing off on. Documentation is proof that something occurred. I can tell you that, special education is document intensive in terms of trying to figure out what occurred. And if there was a NORUP from a year and a half ago, people probably aren't going to remember the meeting that led to the NORUP real in detail, and they might not remember the circumstances of discussion regarding the NORUP. So that's where that documentation of what happened that year and a half ago is really important. Clarity of communication. You want the district to know what you're thinking, and you want to know what they're thinking. And that's really the purpose of prior written notice, not just the decision, but the why. And just err on the side of the clarity of communication, identify the why, put that in what you share back with the district. It's a paper trail of chronology of events, of communications. It will help you recall past events when you're talking about them in the future. And if you share the information externally, it's going to be something somebody else can rely upon, whether it's a hearing officer or a private evaluator or whomever. So documentation is important no matter what you do in special education. It's particularly important in responding to prior written notice, and it will help you kind of get results that will benefit your child, in our opinion. We covered a lot tonight, and again, this is a really important topic, but before we're going to take questions, before we finish, I just wanted to spend a minute and introduce two of our colleagues. Wendy Dwyer is here tonight. Wendy is a very valuable member of our team and somebody that is very involved in the special education community. Wendy, it's nice to have you tonight, and thanks for your help with this. And also Ruth Kistner. Ruth has been an educator throughout her life. She's a former special education teacher and a curriculum specialist, and Ruth is a very valuable member of our team, and we work with these ladies every day, and they care very much about helping children. So thank you both for being here tonight. thank you for listening. I hope, and Christine, we both hope that this was helpful. And I'm sure there are questions, so please ask away.
Thank you so much, Scott. And I can't agree with you enough. Documentation is absolutely key. The chronological timelines, can't tell you how important it is that parents have that together because you know what's going on with your kid better than anybody else, right? So when you share that, it really helps the other party know. So I do have some questions. I thought we had some good questions. One parent said, I asked for an independent eval and the district just said no in an email, but issued me a PTRE. What can I do?
I mean, I'll start. So the PTRE is the way the district's trying to kind of get out of dealing with the IE issue. And that says that they think that there is a need to reevaluate at that time. So in that situation, you can ask the district to send you a NORP saying that they are disagreeing with your request for independent educational evaluation and for them to identify why, the reason why, and they should do that. They're required by law. That's what this prior written notice is. So push them on that issue. And then in terms of the permission form, permission to reevaluate, think carefully whether you want that. If you have a good, competent district evaluator that is reasonably, can do the evaluation soon, you may want to at least consider it. But if you're going to say no to that, check that you disapprove, get that back, and write on the permission form, I requested an independent educational evaluation. It is needed because, and identify your reasons, and the district, effort to have this reevaluation done by district evaluator is not acceptable, something like that. And you could probably say it better than I just said it, but that's what you need to do. Two fronts: ask for the NORP and return the evaluation process or form.
Great. I forgot to mention, we're going to stop the recording now. My apologies. And while we're